Now that the initial appearance has taken place, the preparations of the proceedings have started, culminating then in the so-called confirmation of charges hearing. What will take place now in preparation of that hearing is that first and foremost disclosure of the evidence will take place. Evidence which is both incriminating and possibly exonerating for the suspects, both by the prosecutor and at a later stage by the defense. The second big issue which the Chamber will have to deal with, and to a certain degree also the parties, is the taking of protective measures, which may include, for instance, redactions, which is the non-disclosure of certain information in witness statements or other documents. And a third thing which might take place now in the preparation phase is the possible victims' participation.
Actually, the prosecutor has the duty to investigate both incriminating and exonerating circumstances equally. Then, in the context of the disclosure proceedings, Article 67(2) of the statute provides that the prosecutor shall disclose to the defense all evidence of a potential exculpatory nature, that is to say, all the evidence that he believes shows or tends to show the innocence of the suspects or to mitigate their guilt or may affect the credibility of the prosecutor's evidence. Together with the evidence of a potential exculpatory nature, the prosecutor shall also disclose to the defense, by way of permitting inspection, any documents, books, photographs, or tangible items that, in his view, are more broadly material to the preparation of the defense. Then, according to the decisions on disclosure of the Chamber issued on 5th of April 2011, the exculpatory evidence, as well as the evidence subject to inspection as material for the preparation of the defense, is not only to be disclosed to the defense, but shall also be communicated, so made available to the Chamber, for the purposes of the decision as to whether the charges against the suspects shall be confirmed or not.
The purpose of the confirmation of charges hearing is to exercise a check on what the prosecutor has collected and the strength of the case of the prosecutor. It is a check on the file of the prosecutor, because during the confirmation of charges, which is not a trial, witnesses logically will not appear. They will not testify, be examined and cross-examined in the courtroom. The Chamber will only decide on the strength of the witness statements, meaning in paper. What is the strength of those witness statements? Are they enough to establish substantial grounds to believe that the persons prosecuted have committed the crimes as charged by the prosecutor? It is not the purpose of the confirmation of charges to decide if those persons are guilty or not. This will be decided at trial by different judges. The process of confirmation of charges is starting in the two cases in Kenya right now, after the initial appearance. The confirmation of charges will be done on the basis of a document which the prosecutor has not yet presented, but which he has to present at the latest 30 days before of the start of the confirmation of charges, which is the document containing the charges. It is at that time that we will know exactly the scope of the cases as presented by the prosecutor. After the confirmation of charges, the Chamber has 60 days to issue its decision. Its decision may be either to decline to confirm the charges. This has been the case in the Abu Garda case, where actually the proceedings were stopped after the confirmation of charges because the Chamber declined to confirm the charges. In this case, proceedings are stopped. There will be no trial. This does not prevent the prosecutor, on the basis of new evidence, to come back and request the Chamber again to confirm the charges. This has never been done for the moment by the prosecutor. The Chamber may also confirm all the charges, or confirm part of the charges and decline another part of the charges. An alternate solution for the chamber is to go back to the prosecutor and to request the prosecutor to present more evidence or to conduct further investigation. Or finally, if the chamber disagrees with the charges as presented by the prosecutor, the chamber may go back to the prosecutor and request the prosecutor to amend the document containing the charges. This was done in the Bemba case, where the chamber did not believe that Mr. Bemba has criminal intent under Article 25 of the Rome Statute and asked the prosecutor to modify the charges in order to present a new document containing the charges under Article 28 of the Rome Statute, which is common responsibility. That's all the different options which are in the hands of the pretrial chamber.
The government of Kenya has lodged a challenge of the admissibility of the two cases, and the chamber will decide on this challenge in due course after it has heard the submissions of the prosecutor and the defense, as well as the victims, all of whom have been directed by the chamber to provide their submissions to this question until the 28th of April 2011. The consequence or the implication of that challenge by the state is that the prosecutor in general has to suspend his investigation. However, the Rome Statute allows him, under specific circumstances, to receive authorization by the pretrial chamber to continue with certain investigative steps. Other than that, the Rome Statute does not impose any impediment or any obstacle to the proceedings, in particular the disclosure of the evidence, and proceedings can unfold before the chamber normally.
The Rome Statute provides for different rights for victims, one being the right to participate, the other one being the right to get reparations. The right to participate is divided into different articles in the Rome Statute. The victims may be remembered that they had the right to participate under Article 15, paragraph 3, when the prosecutor requested authorization to start the investigation. There is a second specific right for victims, which actually they are right now exercising, which is the right under 19, paragraph 3 of the Rome Statute, to present observations on jurisdiction or admissibility. This time it is admissibility because of the challenge of Kenya. There is, in addition to that, a general right to participate. Participation meaning presenting their views and concerns to the chamber. This is Article 68, paragraph 3 of the Rome Statute, and this applies at all stages of the proceedings, including the actual stage, the stage of the confirmation of charges. Actually, there is a specific duty in the rules for the chamber to notify victims about an upcoming confirmation of charges in order for the victims to be able to apply and to participate. This is the first right, which is the right to participate. In addition to that, and it has to be understood that this is a separate right from the right to participate, there is the right to ask for reparations, provided for in Article 75 of the Rome Statute. Victims may choose. They may ask to participate, and then they may not ask to get reparations. They may ask directly to get reparations, but not ask to participate, or they may ask for both. Reparations is not dealt with by the pretrial chamber. It is dealt with only after the confirmation of charges, if they are confirmed, of course, and before the trial chamber. And after a decision is taken by the trial chamber concerning if the person is guilty or not. And in accordance with Article 75, paragraph 2, the chamber can only issue an order on reparations if there is a decision convicting the person who has been prosecuted. In order to explain the process of application for victims before the court, it is first important to remind victims about the distinction made in this institution between victims of a case and victims of the situation. There are two different decisions for victims of the case and victims of the situation. For victims of the situation, it's a decision of November 2010. A decision was taken at the end of March for victims of the case. For victims of the case, victims will have to prove a link with what is mentioned, with the crimes mentioned in the summonses to appear. And I need to remind what are those crimes in order for victims to be able to really identify if they could be linked to the case. For the case number one, the case against Mr. Ruto, Koski, and Sang, it is murder, forcible transfer of population, and persecution. It is only those crimes committed between 30 December 2007 and 31st January 2008, so that's basically 1 month, and in the following locations: Uasin Gishu and Nandi districts for both murder, forcible transfer, and persecution. This is case 1. For case 2, Muthaora, Kenyatta, and Ali, there are 5 crimes. These are murder, forcible transfer of population, rape, other inhuman acts, and persecution. But it's only for 1 week. It's on or about 24 January 2008 until 31st January 2008. For murder, it is only in Nakuru and Naivasha. For forcible transfer, the same, Nakuru, Naivasha. For rape, it is only in Nakuru. For other inhuman acts, as in murder and forcible transfer, it is Nakuru town and Naivasha. If you are outside, if the victims are outside the scope of the cases, as I mentioned now, then they fall within the category of victims of the situation. It means that they will not be able to participate in the proceedings starting now up until the confirmation of charges, and after the confirmation of charges, if there is a trial. In addition to that, it is important to note that applicants, the victims who want to apply to participate in the cases, need to clearly indicate their wish to participate. If they don't mention that they want to participate, but for example say, we only want reparations, then they will not be considered as victims willing to participate in those cases.
If victims choose to participate in the proceedings that are pending before the pretrial chamber 2 in the 2 Kenya cases, first I need to clarify that the chamber has not decided on the victim status and their procedural rights which they may enjoy at this stage. I can only make a reference to existing jurisprudence of other pretrial chambers, and I can make reference to what other chambers have decided in order to clarify maybe what are the rights of victims at the pretrial stage. Those rights encompass first and foremost the right of a victim to choose his or her counsel, legal representative who will represent that victim in the proceedings. It also comprises the right to attend hearings, to have access to decisions or other filings of parties to the proceedings. It also comprises the right to have access to the transcript during the hearings. It also comprises access to the evidence, at least if it's public, and to make written submissions to the chamber on a particular point of law or fact. And finally, victims, through their legal representatives, have the right, during the confirmation of charges hearing, to make opening and closing statements. What is important and what this whole concept entails is that victims who really wish, who have expressed a wish to participate in those proceedings, have an interest in those proceedings, it also entails a certain degree of responsibility, which is exercised by the victims through their instructions given to the legal representatives who attend those hearings. So in conclusion, victims who wish to participate, and after the chamber has decided whether or not they qualify as victims in accordance with Rule 85 of the Rules of Procedure and Evidence, the chamber will then decide on the exact scope of the rights to participate in the proceedings, and victims will have the opportunity to contribute meaningfully to the confirmation of charges hearing in both Kenyan cases.
Going now to the process of application, I would like to state very clearly that this process is free of charge. The victims should and will not be charged to participate in the proceedings before this court. If they lack the means to pay for a counsel, the court will provide a counsel for them in accordance with Rule 90. They have to present some identity documents, and the main identity documents are the following: passport, national identity card, birth certificate, or driver's license. These are the four main documents which are mentioned in the decision issued by the Chamber on March 2011. I need also to stress that there is a section in this court which has been established by the registry and which is there in order to assist them to participate. They must, whenever they want, try to get into contact with this section, which is called here VPRS, Victims Participation and Reparations Section. This is the section which is in charge. The duty of that section is to assist them. It is highly recommended that they contact that section in order to know how they can find the standard form in order to be able to apply, and how to fill that standard form in order to be able to participate in the proceedings. The Chamber has said that the deadline for that section to present complete applications is 8 July 2011. However, victims should give some time in order for that section to complete the process of presenting those applications to the Chamber. It is therefore highly recommended that they come several weeks in advance, possibly 3 weeks in advance of that deadline, 8 July, in order to give some time to the VPRS to be able to complete the process. Therefore, the best is for them to apply as soon as they can, because basically it means that they have 8 to 10 weeks from now in order to be able to participate in the confirmation of charges. Concerning the distinction between a victim and a witness is somebody who is called either by the prosecutor, by the defense, or eventually by the judges themselves, to come and testify before the court. A witness appears before the court and answers questions put to him or her by the prosecutor, the defense, or the judges, or eventually the victims. A victim is somebody who has suffered harm as a result of crimes committed, either crimes within the jurisdiction of the court for victims of the situation, or crimes as described in the summons for the victims of the case, and that person wants, through a legal representative, to present his or her views or concerns to the judges. Victim can, of course, also be at the same time a witness either called by the defense, by the prosecutor, or by the judges. However, a person can choose not to be a witness. Giving a witness statement is a voluntary process before the ICC. So somebody who is a victim can decide not to be a witness. But the fact to decide to be a witness does not impede that person to be a victim and to request either to participate or to receive reparations after the proceedings, or both.